All rise. The Court of Appeal and for the 5th District of the State of Florida is now in session. The Honorable Eric J. Eisenhower, Judge, presiding. All persons having this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session for the 5th District Court of Appeal. Before we get started, if you could please make sure you've silenced your cell phones so that the attorneys aren't interrupted during their argument. On my right is Judge Cohen, and on my left is Judge Sasso, and we make up the panel today. I'm Judge Eisnagel. And with that, we will proceed with the first case. First up today is 17-2542 LOSTAGLIO versus Susan Adams et al. Okay. And normally we'll do 5 minutes for rebuttal, but we're happy to do whatever time suits you, whatever time you prefer. If you would just let me know, if the appellant would just let me know when you're ready to begin. You're the appellant?
Yes, Your Honor.
Okay, whenever you're ready.
5 minutes is fine.
Okay.
Please, the court. Good morning again. Attorney James Evans for appellant Anthony LOSTAGLIO. Your Honors, this case was brought to trial where 9 plaintiffs, all members of the same 2 limited liability companies, sued their fellow LLC member, Anthony LOSTAGLIO, not a managing member, just a member. There were 2 managing members named Shimento and Horton. Horton defaulted and the other co-defendants settled, leaving Anthony LOSTAGLIO, the appellant, as the last man standing, as you might say, in front of the jury with myself. The complaint, it is our position that the complaint was based upon a legal fiction that their attorneys coined as, and I quote, de facto managing member. The complaint and the amended complaint failed to state a cause of action, and the case never should have proceeded to jury trial. Former Judge Scott DuPont or allowed fundamental error to be committed when the case was sent to the jury.
The jury was not instructed on this de facto managing member theory, though, correct? They were instructed appropriately on the law.
They were not instructed on the de facto managing member. I don't believe in hindsight that they were instructed appropriately on the law.
Okay.
You believe that there's no cause of action for an implied fiduciary duty?
Under these set of facts,
I just, as a general concept, is there a cause of action for implied fiduciary duty?
yes, Your Honor.
Okay. And so if that is so, then it becomes a question of fact as to whether the circumstances and the facts involved in this investment plan gave rise to such a duty, correct?
I don't believe that's the case. I believe that it is a question of law because of the limited liability corporations and the governing documents. In other words, if there was no contract, if there were no articles of organization, if there were no operating agreement, if there were no subscription agreements that outlined the rights and duties of the parties, then arguably it could be based on fact and based on that implied theory of
Wasn't there, there was evidence that your client held himself out as an expert in the area, assured the investors that the product would be successful, and they had the purple book that was distributed, and he made representations as to that. Those facts, you have to take the facts in the light most favorable to the investors, do you not?
You do, Your Honor, and those same investors, however, that testified that that was the case also claimed that they never saw a fully functioning product, and that evidence was contradicted by their own expert, Robert Pawa, who was later appointed and acted as the president of the company.
Well, but there is evidence in the record that the projected value was grossly exaggerated, was there not?
There's evidence in the record that there were projections in the Purple Book that was not created by my client, mind you, that was created by the managing members, specifically Horton, that defaulted, and those projections were never met. Those projections were overstated. As to the value of the software application itself, Appellant LOSTAGLIO never placed a value on that.
What's missing from the testimony, as far as you're concerned? What would it have taken here, from your point of view?
I believe it would have taken.
I mean, they testified there were misrepresentations on, your client's background, on the risk that was involved, and they made numerous sort of allegations at trial. So, what else did they need to testify to, or what other evidence did they need?
I think under Florida law, based on DENISE v. Camacho, they had to bring individualized counts. They had to prove special injury. There's a two-pronged test.
Well, the jury separated the claims, right?
The jury separated the monetary amounts, but that's all they separated. If you look at the jury form, it was laid out collectively, just like the complaint. In other words, it referred
But there were
to-
counts that your client was found to not be liable on, and other counts that he was found to be liable on, correct?
He was found, yes, Your Honor, he was found liable on one of the three counts.
So the jury rejected two other counts. So they separated out the causes of action, did they not?
I believe they did as the pleadings were framed, but they did not as to the individuals themselves.
Well, they didn't separate out Dudley and Henderson?
As to the monetary awards, they
They did,
separated
didn't they?
out everybody.
The jury separated those two out, right?
They did. They did. As to the money awarded, they did. But it's my position that because they were members of the LLC, for one member to sue another member under Florida law, granted, when the motion to dismiss was heard, I was not the attorney. And De Niro was, I don't even think, case law at that time. That came out in 2014. We're dealing with a span of years here. But when De Niro Investments versus Camacho comes out, the Florida law clearly states you just can't sue. You can't have one member suing another member unless that two-pronged test is met. There has to be some.
And that specific, and I understand, the change of attorneys, that specific objection wasn't raised. You're hearing a fundamental error analysis. And looking at that in our role when evaluating fundamental error, wouldn't the facts that have been alleged and ultimately found by the jury give rise to the special injury that's required in De Niro?
I respectfully do not believe that they would,
And why not?
Your Honor, because there were no individual allegations made as to any alleged acts or any alleged damages. In other words, there was a core set of facts. There were approximately 30 paragraphs, I believe paragraphs 49 to 79 of the complaint, whatever that number comes to, that core set of facts that were relied on as to each element, as to each plaintiff, as to each damage.
Didn't each plaintiff have different representations that they relied on, and they testified as to those representations in terms of, whether the technology was going to be there, who was going to ensure that the technology acted as it said it was, and that sort of thing? There was individual inducements according to the plaintiff's testimony.
There were 9 plaintiffs that proceeded. Actually, there were 10, and then one passed away, rest in peace, before the trial. So there were 9 that actually were on the verdict form. 4 of those 9, only 4 of them actually had any conversation with Appellant LOSTAGLIO, and they all relied on the same alleged statements. The other 5 just invested their money. They spoke to others that were not involved in the lawsuit.
And so your position is that because of that and because they signed different subscription agreements, et cetera, suffered different damages or different amounts of damages, your position is that they were required to allege separate causes of action individually? Each one was required to, they couldn't sort of allege one cause of action?
Yes, I believe that each...
Can you explain to me how that's fundamental error, though? Walk me through that analysis.
Well, yes, Your Honor.
I mean, let's assume for a minute that they were required to, every single one of them was required to have their own count in the complaint. Walk me through the fundamental error analysis here.
It's fundamental error, I believe, as the Honorable David Monaco states in his book, because it goes to the foundation of the case. You know, it goes to the heart of the case. It goes to the merits.
Well, that's kind of a conclusory statement. Convince us that it goes to the heart of the case.
It goes to the heart of the case.
The mere fact that they pled it all together instead of separating it out.
Well, because what we have here is we have one injury. We have a failed business and nothing more. As bad as that was under the circumstances relative to the amount of money that was raised, you have 2 gentlemen named Shimento and Horton that came up with this idea and decided to start the business and relied on my client as an advisor, as a consultant.
Oh, but that's disputed in terms of the facts. So, there was testimony that investors relied entirely upon the representations made and the sales pitch, or it could be interpreted as a sales pitch made by your client at various, at the time of various offerings.
4 of the plaintiffs alleged that they relied on statements that my client made at, I think, 2 meetings that were held. However, once again, he never received a salary. He never received any money. He was not an employee of either LLC. He was not a managing member. He did not control what happened. He did not. He did not have the control.
He had control over his representations.
He had control over what he said, but he did not say anything that was false. Once again, I'd ask you to remember that the plaintiffs that made...
But that's a very disputed issue as to whether he said things that weren't false. The plaintiffs alleged that he did say things that were false, that he made fraudulent misrepresentations.
And they also, that's true, and they also alleged that the application never worked, which is why we called one witness.
I mean, if the jury believed that your client never made false representations, would you be the appellant here? If the jury believed, didn't the jury decide that your client did make false representations?
I don't think with all due respect, no, I don't think so. Because the falsity of the allegations were involved in 2 counts, the fraudulent misrepresentation and the securities fraud. And he was not found liable.
It also would be on it's tied into the implied fiduciary duty as well.
Well, I once again go back to the fact that they claimed the application never worked. That's why we called one independent witness, the most independent witness we could find, the CPA, who clearly stated it worked, she downloaded it, she received funds. And those same 4 investors that claimed that they received and heard false statements, they then went and hired attorney Mark Perry. They went and hired Robert Pawa. Robert Pawa comes in 2013 prior to their 3rd round of investment and gives them a clean slate, so to speak. They all signed documents at that point relieving liability from everyone involved in what they coined the board of directors. And then to turn around later after it fails and claim that they were lied to, basically, it should not stand. Under Florida law, there is an implied theory that is available, but it's not available under these facts.
And isn't that the issue with the fundamental error analysis? The fundamental error in civil cases has been reserved for those cases where it doesn't exist as a matter of law. For example, punitive damages when there's not punitive damages available, or statutory penalties where the statute has been amended. Here, aren't you arguing that there was a theory they could have proceeded on, it just wasn't pled? So it's not that it doesn't exist.
I don't think they could have proceeded under the implied theory because of the contract involved. You know, in other words, but for the operating agreement, but for the articles of organization, but for the subscription agreements, yes.
So if you have a contract, then your client can say anything under the sun, can lie till the cows come home, and there's no cause of action.
No, that's not the case, but you have to look to the four corners of those documents. And you have to consider what should have been presented to the jury. And if you don't have any other questions, I think I'm to my 5 minutes. Thank you.
Thank you, counsel.
May it please the court. Good morning. My name is Doug Stanford. I'm here on behalf of the appellees who respectfully request this honorable court affirm as to both issues on appeal. I want to address the De Niro two-prong test. That is an instruction that could have been requested in the jury instructions, wasn't requested, wasn't included in the jury instructions, and was not objected to. The jury instructions without that two-part test were not objected to, so that issue is not preserved. With all due respect to opposing counsel, what he's doing is re-arguing the facts before this court, and he's basically asking this court to reweigh the facts on an issue that wasn't even preserved for appeal. I don't think that can be done. As far as whether fundamental error occurred as to the breach of fiduciary duty account,
Isn't I recognize that particularly in civil cases that fundamental error is a very narrow concept, but it seems that giving the jury correct instructions comes about as close to the core of the case as anything does.
it does, Your Honor, and I don't have it, I may have it in my outline. In Feliciano v. School Board of Palm Beach County, which is 776 Southern 2nd 306, it's a Florida 4th DCA case, said even if jury instructions are fundamental error, failure to preserve the objections to the jury instructions cannot be cured by application of the fundamental error doctrine. And the point of that is to avoid situations where something's not objected to in the jury instruction.
If it's objected to, that analysis is just circular because if it's objected to, it's not a fundamental error analysis. It's a harmless error analysis.
Right.
I mean, you always are going to have the situation where it wasn't objected to or we're not discussing fundamental error.
I'm not following. I'm sorry, Your Honor.
If it's objected to, then we're not looking at fundamental error, we're looking at harmless error. So whenever we're discussing fundamental error, by its very nature, we're discussing cases where there was a lack of objection.
Right.
So that 4th DCA case can say what you represent, but the analysis is circular. It's not persuasive.
I would still submit that the policy of fundamental error is supposed to be applied very guardedly by the courts. And I don't believe that it's appropriate in this case because I believe that the jury was instructed properly on the law. The jury instruction actually tracked this court's case in Crucell v. Mong, which was, bear with me 1 second, Your Honor. It was 59 Southern 3rd, 1178, and that's a Florida 5th DCA case. Jury instruction number 11 actually tracked that case on implied fiduciary duty. And jury instruction number 11 read, "Where there is not an express fiduciary relationship, one may be implied in law based on the specific factual situation surrounding the transaction and the relationship of the parties. An implied fiduciary duty will lie when there is a degree of dependency on one side and then undertaking on the other side to protect and/or benefit the dependent party. A fiduciary relationship may result from an offer of assistance where the nature of the proposal is one that is naturally calculated to repose confidence and trust in the one making the proposal, and the relation and its correlative duties need not be legal, but may be moral, social, domestic, or merely personal." And as this court has noted, there was testimony and evidence adduced at trial that there were misrepresentations made, that the appellees relied on the misrepresentations by the appellant, and that he held himself out as an expert and said that, you can't lose on this one. This is a can't-lose investment. I'm the president, executive vice president of IBM. I can bring this to market. I have people who can bring this to market. There was testimony that the appellees relied upon all of that.
Do you think that the governing documents of the LLCs created a duty only between Gimento and Horton and negated any type of duty between the other members of the LLC?
I had not thought of, I would have to think about that some more, Your Honor. What I can say is that regardless of that when Mr. LOSTAGLIO made these representations, that he created a duty, an implied fiduciary duty as outlined in Crucell v. Mong and as stated in jury instruction number 11.
What if I were forming a business and so I'm making a sales pitch and my sales pitch is just exaggerated, but then I present you with documents and those documents say that you're not to rely upon any representations that had been made in making this investment.
I'm not sure that.
Or I'll put it in another context. You buy a car. Anytime someone goes in to buy a car, the contract for purchase of the car is going to specifically state that there are no warranties other than as set out in the documents, and you can't rely upon any representations that had been made by the salesperson in an analogous situation.
I understand the question, and I would submit that still that doesn't give somebody carte blanche just to make willy-nilly misrepresentations with impunity. And I don't think that's the state of the law that would allow that. And I believe in this case that the misrepresentations that Mr. LOSTAGLIO made, particularly in the context of, again, him saying he's the executive vice president of IBM and all of that, I still believe that in spite of that it created an implied fiduciary duty.
But it seems fairly clear, or it seemed to me from reading appellant's brief, that his position was that the documentation, the governing documents of the LLC created a special duty only between the two, Gimento, I don't know that I'm pronouncing that right, and Horton, and not the other members of the LLC. But you're not able to address that today?
I don't agree with that position, Your Honor. Again, I believe that in spite of that there was still an implied fiduciary duty created when Mr. LOSTAGLIO made the statements that he did, and they invested in reliance on those statements, in spite of what may have been stated in the agreements.
Can you cite to the language in the document, in the LLC documents, that supports your position or that contradicts appellant's position?
No, sir, I can't, Your Honor.
Okay.
As stated in Hernandez v. Kissimmee Police Department, which is 901 Southern 2nd 420 by the Florida 5th DCA, as a general rule, reviewing courts will not consider claims of error which are raised for the first time on appeal. It's the function of the appellate court to review errors allegedly committed by the trial court, not to entertain for the first time on appeal issues which the complaining party could have, but did not present to the trial court. Thus, this court should not consider the appellant's claim of error raised for the first time in this appeal. And if the court does consider this issue, again, I would submit that fundamental error did not occur in this case. And fundamental error goes to the foundation of the case or to the merits of the cause of action, and the appellate court should exercise its discretion under the doctrine of fundamental error very guardedly. As I read jury instruction number 11, it outlined a fiduciary relationship and tracked the language of this court in Crucell v. Mong. Jury instruction number 12 read, the issues to the jury said, the issues for you to decide on the plaintiff's claim of breach of fiduciary duty are first, whether Mr. LOSTAGLIO owed the plaintiffs a fiduciary duty. Second, whether Mr. LOSTAGLIO breached that duty. Third, in order to find Mr. LOSTAGLIO breached that duty, you must find that he committed either fraud or gross negligence. And fourth, whether the plaintiffs were damaged as a result of Mr. LOSTAGLIO's breach of duty. And there's no mention of de facto managing member in any of those instructions. The verdict form had the jury answer the following three questions with respect to the breach of fiduciary duty claim. Did Mr. LOSTAGLIO owe the plaintiffs a fiduciary duty? Did Mr. LOSTAGLIO breach that fiduciary duty? And did Mr. LOSTAGLIO's breach of that fiduciary duty cause the plaintiffs to be harmed? The jury answered yes to each of those three questions. There's nothing in the record illuminating whether the jury answered this way based in whole or in part on a de facto managing member theory or anything else. And as this court said in Norton v. Gregory at 566 Southern 2nd 60, absent clear evidence to the contrary, it must be presumed that the jury correctly followed the court's instruction, applied the law, and considered all the elements of damage. In E.F. Hutton v. Sussman, which is 504 Southern 2nd 1372, the Florida 3rd DCA said, the verdict rendered by the jury is presumed to be regular and in conformity with the instructions given by the trial court. And therefore, this court must presume that the jury followed and applied the law as stated in the jury instructions, and that the jury's verdict finding the appellant liable for the breach of fiduciary duty is correct. And for those reasons, the court should affirm as to the first issue on appeal. The second issue, which we really haven't gotten to yet, is whether the trial court erred in denying the appellant's motion to determine the reasonable amount of attorney's fees and cost. Two things are...
So even though they hadn't argued it, and I guess they were relying upon their brief, you want to go into it anyway?
Go
Go for it. It's your argument.
Well, I mean, are there any other questions about the... I don't really have anything else on the first issue, on the breaching of, on the de facto managing member question. So I'll just briefly argue on the second one. In Van Dypen v. Brown, which is 55 Southern 3rd 612, it's a per curiam case from the Florida 5th DCA. In that case, two plaintiffs prevailed on one of their 8 claims. They were statutorily entitled to attorney's fees for the claim upon which they prevailed, which was an overtime claim. Plaintiffs' counsel made no significant effort to separate out which hours were related to the overtime claim, and instead took the untenable position that virtually all hours expended in the prosecution of this case were based on the overtime claim. The Van Dypen court reversed the trial court's attorney fee award. And in Van Dypen, the court espoused the law that the party seeking attorney's fees on multiple claims has an affirmative burden to demonstrate what portion of the effort was expended on the claim that authorized attorney's fees. If the moving party cannot meet his burden for any reason, including inadequate or imprecise timesheets or record keeping, he or she should not be awarded attorney's fees for those vague or incomprehensible charges. And the party against whom fees are sought should not be punished because of the lack of adequate record keeping by the party seeking fees. The facts in this case are analogous to the facts in Van Dypen. Multiple plaintiffs filed multiple claims. The party seeking fees was not entitled to fees on all of the claims, and the attorney of the party seeking fees made no significant effort to separate hours on the winning effort, and instead took the untenable position that virtually all hours in the case were based on the winning effort. And Van Dypen therefore controls in this case. The appellant had an affirmative duty or an affirmative burden to demonstrate what portion of the effort was expended on the claims that authorized attorney's fees. The appellant should not be awarded attorney's fees for the charges for which he cannot meet this burden. Ms. Dudley and Ms. Henderson should not be punished because of the lack of adequate record-keeping by the appellant. Requiring Ms. Dudley and Ms. Henderson to pay the appellant's attorney's fees on the portion of the claim authorizing attorney's fees and the portion of the claim not authorizing attorney's fees would punish them severely. So under the authority of Van Dypen alone, the order under review denying the appellant's motion to determine reasonable attorney's fees should be affirmed. And the appellant cannot avoid his burden of allocation on the basis that the appellee's claims were inextricably intertwined. The appellant argues that all 10 of the appellee's claims arose out of a common core of operative facts which were inextricably intertwined between all of the counts of the case, and thus it was impractical for appellant's counsel to apportion the time on a claim-by-claim or party-by-party basis. This argument ignores the following crucial facts. The appellant's own defense of the case at trial refutes the inextricably intertwined argument. At trial, appellant's counsel emphasized the fact that 6 of the 10 appellees, including Ms. Dudley and Ms. Henderson, had no contact with the appellant. Cross-examining Ms. Dudley's husband, appellant's counsel established that the Dudleys never spoke to the appellant or received information from him. Cross-examining Ms. Henderson's husband, he established that the Hendersons never spoke to the appellant, so didn't receive information directly from him. In trial, he brought out only 4 of the 10 spoke directly to the appellant. In closing, appellant's counsel argued, quote, "I'm here, and this is important. Of the 10 left, 6 of the plaintiffs admit that they never spoke to Mr. LOSTAGLIO prior to making the investment, never spoke to him. They want you to find him liable for fraud and making a false statement, but they admit they never spoke to him." Appellant's counsel referred to Dwayne and Jennifer Sizemore and Bruce and Denise Bedner as the only 4 out of the 10 that ever spoke to Mr. LOSTAGLIO. The order under review outlined the following facts that I think are very relevant here. The court said the appellees signed different subscription agreements on different dates and under different circumstances. Some of the appellees signed subscription agreements after direct contact with the appellant, others after no direct contact. The appellees invested different amount of money as part of their subscription agreements, and each of the appellees could have brought individual claims against the appellant based upon their own separate and distinct subscription agreement. One appellee could not have sued the appellant on the basis of another appellee's subscription agreement. Thus, the appellee's claims did not arise out of a common core of operative facts and were not inextricably intertwined. The separate and distinct nature of each of the appellee's claims is not negated merely because the appellee's claims may contain some common facts. And even if the appellee's claims were inextricably intertwined, it was not impractical for appellant's counsel to apportion the time on a claim-by-claim or party-by-party basis. Appellee's counsel billed the appellees based on the total dollar amount of their claim versus the total dollar amount of the appellee's claims combined. So applying this formula to the appellant's attorney's fees, the total dollar amount of the claim of the 10 appellees who received proposals and went to trial were $1,002,250. Ms. Dudley's $18,250 claim was 1.8% of that amount. Ms. Henderson's $50,000 claim was 5% of that amount. Thus, the appellant could have attempted to recover 1.8% of his total attorney's fees from Ms. Dudley and 5% from Ms. Henderson. And as to that point, Plappinger v. Eastern States Properties Realty Corp., which is 716 Southern 2nd 315, it's a Florida 5th DCA case, cited by the appellant, is particularly instructive. In Plappinger, only 2 of the 6 counts in the complaint related to a written contract that authorized attorney's fees. To support the award of attorney's fees, the appellee argued that all of the counts were interwoven and intermingled, and because they arose out of the same transaction or set of facts. The Plappinger court held that the appellee's billing records and files did not separate out the attorney's time and effort spent on the respective separate counts. Thus, perhaps the only way of unraveling this puzzle was for an expert witness to testify in his or her opinion what was a reasonable time apportionable to those accounts for which an attorney's fee could be awarded. In Plappinger, the expert witness did that, which made the record support a partial award of attorney's fees in Plappinger. In this case, the appellant can't show what portion of the time or effort was incurred on Ms. Dudley's or Ms. Henderson's claims. The appellant could have unraveled this puzzle by having an expert witness opine as to a reasonable time apportionable for Ms. Dudley's and Ms. Henderson's claims. Because the appellant failed to do this, it is impossible to unravel the puzzle of what amount of attorney's fees should be awarded. Thus, unlike in Plappinger, the record in the instant case does not provide support to determine an amount of attorney's fees to award. In conclusion, as to the second issue on appeal, the appellant served proposals for settlement on the 10 appellees, went to trial against the 10 appellees, only won on 2 of his proposals for settlement. His attorney made no effort to apportion the attorney's fees incurred on the 2 winning efforts. The appellant seeks to punish Ms. Dudley and Ms. Henderson for this failure by having them pay for all of the attorney's fees he incurred and defending against all of the appellee's claims. He's yet to provide any authorities that would support this remarkable and unfair outcome. Could have apportioned the fees as the appellee's attorney did, and Plappinger instead went for 100% of the fees that he incurred, in spite of the fact that he only prevailed on 20% of his proposals for settlement and lost on 80% of his proposals for settlement. By going for 100%, created the situation that we're now in, where the only options are to award him all of his fees or to award him none of his fees. Since neither the facts nor the law support awarding the appellant all of his fees, the order under review correctly awarding him none of his fees should be affirmed. And in light of all of this, the appellees respectfully request this honorable court to affirm as to both issues on appeal. Thank you.
Thank you, counsel. All right, counsel for the appellant, I think you have 5 minutes and 12 seconds. And I'll start that whenever you're ready.
I'm ready, Judge. Thank you. The jury was not properly instructed because Crucell doesn't apply. And Crucell doesn't apply because that was just a relationship that was not in contract. That was all verbal. That was not an LLC. That was not a limited liability corporation circumstance. Each investor knew what they were doing, especially the last 4 that received the most sizable awards, the Bedners and the Sizemores, because they hired an attorney. They hired Robert Pawa to come in, look at everything, and tell him it was safe to give even more money. And Dr. James Kolka, who invested $250,000 after that point. And after that point in 2013, the company was run by the so-called board of directors and Robert Pawa. In any event, for what it's worth, I'd like to say one more thing. If you pull out your cell phone right now and conduct a Google search, it's going to locate you, and it's going to locate the businesses nearest to you. That is the exact same technology that they were trying to launch almost 10 years ago. So in hindsight, there was nothing false. There was nothing fraudulent. In fact, it was realized, albeit by Google and Google money, it was realized, and they were only, say, $300,000 away from being that entrepreneur. If you don't have any questions, that's all I have.
Thank you, counsel.
Thank you.